Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we are going to be discussing artificial disc replacement verdicts and settlements. So I went into one of the databases that I use. Like I've said before in other videos, I use Westlaw, LexisNexis. There's also Verdict Search. And so, we could search for various things. Now, the issue with searching for something like artificial disc replacement is that it's not a category that's already there. For example, if you wanted to search for fusion of the cervical spine, it's already there. So you could just click it and it'll give you all the fusion verdicts. But for artificial disc replacement surgery, it's just not there. I guess it's more of an experimental or newer procedure. And so it's not one of the drop-down listed injuries or surgeries. And therefore, you have to just put it in with quotation marks, artificial disc replacement. And then when it finds that in the search terms, it'll output. So it outputted actually 94 pages worth of cases. And I'll give you a brief summary. Most of the verdicts are between 500, I'd say 400,000 or 500,000 is the lowest I've seen. And then the highest goes up to about 4 million. So for artificial discs. And a lot of the cases also are from California, as opposed to being from New York or another state. I guess California is a place where artificial disc replacement surgeries are being done. So here's the first case. It's actually out of California from San Francisco. And what happened here was the incident happened November 16th of 2009. And it was a slip and fall on a piece of cardboard which had hydraulic fluid that leaked from a compactor. And so the plaintiff was a janitor. He was employed by a maintenance company and he was depositing recycling materials in a recycling compactor. And that was part of his work, and that's when he slipped and fell in November of 2009. Now, the verdict came down in 2014, about 5 years later. And his injury, he had a lot of different injuries, but one of the main injuries is that he needed a prosthetic disc replacement at L4, L5 and a fusion at L5S1. And he actually needed it the following day. So that helps because that shows it's traumatically induced, right? It's caused by trauma. It's not like he needed it 5 years later. He needed it the following day after he fell. And so he also was recommended for an artificial disc replacement at the L3, L4 level. And he sought recovery. He had $394,000 in past medical bills, $3.7 million in a future medical cost or life care plan, $225,000 in past lost earnings, and $513,000 in future lost earnings. That's what he was looking for. The demand before the trial was $2 million, and the offer was $600,000. The trial took actually 1 month. And the jury deliberated for 3 days. It was nine men and 3 women on the jury. So the result was, it was a verdict of $4,383,682. But the actual award was $3.4 million because I guess the jury found some percentage of liability to the plaintiff, and you can't recover for your own percentage. So yeah, that's why the verdict was reduced from 4.3 to 3.4, but still a pretty good verdict, 3.4 million. And it looked here like the jury found that, so one of the companies was 79% at fault, the maintenance company was 10%, and they gave the plaintiff 11%. So the plaintiff was 11% at fault. But the jury totaled the damages of 4.3, so because of the reductions, he received 3.4. The next case is out of California as well. This one is Sacramento. And what happened here was, it was on April 29th of 2010, the plaintiff, who was 34 years old, was driving and his vehicle was rear-ended. And so plaintiff, like I said, was 34 years old. He was, I believe, a periodontist. So he sustained a disc protrusion at the C5, C6, which is the neck, the C, the cervical. And he also had facet pain from C4 to through C7. And he treated with radiofrequency ablation, but it was unsuccessful. So at that point, he underwent an artificial disc replacement at C5, C6, and this was 3.5 years after the accident. So he claimed that it affected his work, his dental practice. He used to work 6 days a week, but now he could only work 3 days a week, and things like that. And he sought recovery of $140,000 in medical bills, $550,000 in future medical costs, and $6 million for past and future lost income. And he sought recovery for his past and future pain and suffering as well, which, pretty much is standard in not every case, but pain and suffering usually in every case. And whether you have medical bills or lost wages, those are just other categories of damages. So what happened here is that the jury found that the defendant's negligence was a substantial factor in causing the plaintiff's injuries. And then it also found that the plaintiff's damages totaled, it was $3,613,909.18. Don't forget the 18 cents. So it broke down as $140,488 for past medical costs, $450,000 for future medical costs, $300,000 for past lost earnings, $1,072,000 for future lost earning capability, $400,000 for past non-economics, which is the pain and suffering, and $1.25 million for future non-economics. And so altogether, it was $3,600,000. And actually, the demand that the plaintiff made to settle the case was $3,500,000. So very close to the verdict. And the offer was $600,000. And the trial took 12 days. The jury deliberated for 1.5 days. And it was 6 men, 6 women on the jury. And it says here, defense counsel moved for a judgment, notwithstanding the verdict, and for a new trial, but the motion was denied. And after an awarding of pre-judgment interest and costs, the total judgment entered was actually $4.2 million. So that's good. They were able to get more. And I think I said, right, that the incident happened in 2010 and the trial happened in 2014. So about 4 years later. So it sounds like California is doing it a little quicker than New York. New York, sometimes it takes more than 4 years. Here's another case. This one's also from California. And so this one, what happened here, the date of the trial was March 10th of 2020. And the incident happened in 2018, so only 2 years difference. The plaintiff was Maria. She was 51 and a home health nurse. And she was driving her car when it got broadsided by a tow truck. And so the defendants admitted liability. And so she sustained injuries. She had fractures to the wrist, ulna, the radius, lumbar fractures at L1, disc protrusions at C5, C6. And so that's basically the injury that she had. And it says here that her lawyer argued that she will eventually require an artificial disc replacement to treat her neck injury. So I guess the doctor said that and the lawyer argued that, but she didn't actually have it in this case because she had this, it says a 2 to 3 millimeter cervical disc protrusion with mild central canal narrowing at C5, C6. So that's where she needed the artificial disc replacement. And she sought recovery of $121,000 in past medical bills, $125,000 in future medical costs, $196,000 for past lost earnings, and $1.4 million for future lost earnings. And so she also sought, of course, recovery for past and future pain and suffering. And the total that her attorney asked the jury to award was just over $3 million. And so the demand before it went to verdict, the demand from the plaintiff was $1.1 million. The offer was $620,000. And so the verdict was $2.5 million. And the trial took 5 days. And what happened was it broke down as $121,000 past medical costs, $125,000 future medical costs, $196,000 for past lost earning capability, $1.2 million for future lost earning capability, $200,000 for past pain and suffering, and $658,000 for future pain and suffering. And altogether, it was $2.5 million, but because there was a post-trial motion in an attempt to recoup $100,000 in costs and $125,000 in interest because they beat what's known as a 998 demand. And so according to plaintiff's counsel, after recovery of costs and interest, the final judgment is actually going to total $2,796,988. And I think a 998, that's something they have in California, where basically you tell them, hey, it's like an offer of judgment. You allow them to settle for the amount. Maybe it was for the 1.1 that they were requesting. And if you beat that, oh yeah, it does say here 1.1 million. That was the plaintiff's demand, right? That's what they wanted. And it says here CCP 998. So since they beat the 1.1 million, they got 2.5. They get their attorney's fees and some interest and costs and interest. So they got more. Instead of 2.5, they got close to 2.8. Here's a case out of Florida. Now, what happened here was that it happened March 9th, 2001, the incident, and the trial was in 2004, so about 3 years later. Plaintiff was Deborah. She was a 37-year-old clerical employee for a sheriff's office, and her Toyota Camry stopped at a red light, and when she was waiting to turn left, the defendant extended cab pickup truck rear-ended her at a speed of about 25 to 30 miles per hour. So it was basically a rear-end crash. And what happened in terms of her injury was that she had a cervical fusion, and it says she had an experimental total artificial disc replacement in which surgeons connected her vertebrae with a ball bearing to enhance her range of motion. That's interesting. I haven't heard of that one before. But she sustained herniations at L5S1, C4, C5, C5, C6. She suffered headaches. She had 2 percutaneous discectomies, cervical and lumbar. She had a revision discectomy to the lumbar, and then she had that cervical fusion with the experimental artificial disc surgery. And she returned to work but had to quit 8 months later because she just couldn't work. She had too much pain. The plaintiffs demanded the $10,000 policy limits pre-suit, but Allstate refused. The plaintiffs served a proposal for settlement for $600,000, in which the defendant again refused. The plaintiffs verbally offered to settle for $800,000, and this is later. The $600,000 was in November of 2002, and the $800,000 was in June of 2003, and made a written offer to settle for $1,050,000 in November 2003. And the insurance company, I already said who it is, it's Allstate, all right, they declined to counter either offer. So they were always saying, no, we're not going to pay. And see, originally it was only a $10,000 policy, but because they didn't negotiate and didn't make an offer, the policy became open. So that's an example of bad faith. And so the offer was in December of 2002, the insurance company made proposals for settlement offering $90 from each defendant to the plaintiff and $10 from each defendant to, I guess, her husband to settle punitive damages. And the plaintiffs rejected these proposals. I mean, I don't know, $90. I've never even heard of such an offer. I said, I'll offer to buy you lunch. It's like a joke. But then in May of 2003, they offered $370,001 to the plaintiff and $5,001 to, I guess, her husband to settle the entire case. And the plaintiffs rejected these proposals. So the verdict was, it was a total verdict of $2,103,438. And this was in Palm Beach County. Yeah, so pretty good verdict, you know. But yeah, that's an example of the insurance company just being greedy. $10,000 they could have settled for, and they opened up the policy, and now they have to pay whatever the judgment would be. And so the verdict broke down as $312,000 for past medical costs, $100,000 for future medical costs, $94,000 for past lost earnings, $97,000 for future lost earning capability, $500,000 for past pain and suffering, and $750,000 for future pain and suffering. That was for Deborah. And then for the husband, it was $125,000 for past loss of consortium and $125,000 for future loss of consortium. So a total of $250,000 for that. And altogether it came out to the 2.1 number that I mentioned. Yeah, so you see a lot of these cases. Here's another case out of California. This is Orange County. This one was a 55-year-old lady. And what happened to her was that she, on September 15th, 2015, she was 55. Her name was Tammy, or is Tammy, a real estate commercial investor. And she was driving when her vehicle entered the intersection. and was broadsided by a vehicle for the defendant. And they admitted liability. And one of the injuries that she had here was she underwent an artificial disc replacement at C5, C6, and C6, C7. She had some other injuries too. She had a mild traumatic brain injury, a concussion, post-concussion syndrome, impingement and tear of the AC joint in her shoulder, resulting in traumatic arthritis. So she had a lot, a few different injuries. Now she had a C5, C6 herniation and extrusion at C5, C6, and C6, C7. She had both. But, an additional injury that she had was this artificial disc replacement at C5, C6, and C6, C7. And so she sought recovery of everything. The jury determined that her damages totaled $2,082,500. Her future medical costs were $182,500. Her past pain and suffering was $400,000, and her future pain and suffering was $1.5 million. The trial took 8 days. The demand was 1.497, so 1.4, and there was also one of these 998. So the demand was 1.4. They beat it, right? They got over, 1.5 just for future pain and suffering. So the demand was 1.497, and the offer was $603,000. The jury deliberated for 4 hours. And so there's more cases. I mean, they're all, for some reason, a lot of these cases are car crash cases. Here's one in Los Angeles County. This one was just under $2 million. It was $1,987,000. Actually, I know the plaintiff's attorney. He's a good attorney. Actually, we're working on a few cases. He's an interesting attorney. He has cases both in California as well as Florida. He's licensed in both places. And so what happened here is that on September 10th, 2018, the plaintiff, his name was Paul, or is Paul. I keep saying was because it's in the past, but they're still alive. So anyway, September 10th, 2018, Paul, 29, he's a production specialist at an aerospace factory. He's driving his truck, and an ambulance runs a red light and strikes the rear driver's side of Paul's truck bed. And at the time, the defendant is acting in the course and scope, meaning they're working in the course and scope of their employment for the medical services ambulance company. And so the injury that Paul sustains, he has a lot of different injuries here. It's listed, it's like 2-3 pages worth of injuries. But one of the things is that he's a candidate for an L4, L5 artificial disc replacement. So that's part of the case. And so the verdict, the jury, by the way, finds that the defendant's negligence is a substantial factor in causing the harm. And I already said, right, the total verdict was $1,987,000. It was broken down as $40,000 for past loss of consortium, $75,000 for future loss of consortium, and $115,000 total for the wife. And for the husband, the injured party, $422,000 for future medical costs, $750,000 for future pain and suffering, and $700,000 for past pain and suffering. So a total of $1,872,000 for the plaintiff and $115,000 for the wife. And so the total is the 1.9. And the demand was $1 million, and they had the 998, the offer of judgment, which they beat, and the offer was $380,000. The trial took 10 days. The jury deliberated for 5 hours, and the plaintiff is going to seek prejudgment interest and the 998 costs for beating the statutory offer. I don't want to go through every single case. There's 94 pages. Like I said, there's a lot here, but you can see what they go for. Here's one for 1.7 million, also out of California. I'll just focus on the artificial disc component. It says here, the plaintiff had a cervical arthroplasty at C4, C5, and C5, C6 with artificial disc replacement. Here's one, a mediated settlement in Los Angeles, 1.5. And this one, I also know the plaintiff's attorney. He's a famous attorney, very good attorney. And it says here that the plaintiff underwent an artificial disc replacement at L5S1. And this is back in 2009, so this is quite a while ago. The 2009 was when the crash happened in June, and it settled in 2012, so about 3 years later. Here's a settlement for 1.5 million. This is another case. This is a 2010 date of incident. And a 2010 trial date, a 2007 date of incident. It was a 49-year-old executive director. His vehicle was struck by a vehicle operated by a minor. And I guess the teenager crashed into him, and he had an anterior lumbar interbody fusion at L5-S1 with an L4-L5 artificial disc replacement. And so that was the 1.5. It settled for 1.5. And as you go down, they're just ordered by number. So the highest case we already talked about, that was the 4.3 at the beginning. Now we're at 1.2. And this is also out of Los Angeles. This case, it looks like, happened in 2014. A 33-year-old, her name is Ashley, instructional trainer at a college. And so it happens December 2014, and the settlement is 2018, so 4 years later. And she's recommended for an artificial disc replacement at L4, L5. Or actually, that one went to trial. I'm sorry, that one, it was a jury verdict, 1.225, 1,225,000. 5 days in trial, 3 hours of deliberations, 12-0 causation. Here's another one out of Los Angeles, 1.2 million. But you get the idea. I mean, they're usually in this range. I guess the person who asked me to make this video wanted to know what the ranges are, so you could see 1.2 million. And this is somebody who didn't have, but requires, that's medical necessity, in the future will eventually require a 2-level artificial disc at L4, L5, and L5-S1. And that was that case. Here's another one out of Los Angeles. And this one, actually, I also know the trial lawyer who handled this one. He's a very good lawyer, very experienced. This happened in 2013 in September, the incident, the crash, and the case, the court date was January 24th of 2018. So about 4 years or 4.5. And so this one, the plaintiff underwent artificial disc replacement surgery at C4, C5, and C5, C6, and she had the surgery. And this one, the jury determined that her damages were $1,174,000 total. And here's another one for 1.1 out of Los Angeles. A lot of them are, for some reason, out of California, like I said before. Another one for 1.1 out of California. This one, the injury was that the plaintiff continued to experience pain and underwent a 2-level artificial disc replacement with screws. So this was he actually had the artificial disc replacement. So I would say, on average, they're going for like anywhere from 1 to 4 million. If we scroll down a little further, we could see that some of them even go for less. If we go all the way to the bottom, we see the lowest, because they're organized by amount. The lowest number that I saw was actually somebody who ultimately was recommended for an artificial disc replacement at C4, C5, but did not undergo the surgery. They had 2 epidural injections at the C5, C6, and surgery was recommended, but he had not undergone surgery at the time of trial. And so it was a plaintiff. He was he is 38, a ride-hailing driver. So I guess he's like a taxi driver and videographer. And what happened was his vehicle was struck in the rear by another vehicle. And so this is also out of Los Angeles. And the verdict for him was $435,000. So that's the lowest case I saw for artificial disc. And the next lowest was actually out of New York, but it was Oneida, which is like upstate, way upstate, Oneida County, Oneida Supreme Court. And what happened here was it was a lady who was 25 years old, and she, on September 13th of 2002, she was a college student, and she was driving on Route 5 in New Hartford. And when she was slowing down in traffic, her vehicle's rear end was struck by a trailing triple axle dump truck. And so what happened here was that she returned to her orthopedic surgeon after a discography, and the orthopedic surgeon said that he recommends an artificial disc replacement at L5-S1 with interbody stabilization. So she didn't have it, but she had the recommendation for it. And the case settled for $500,000. Here's another settlement for $500,000, but this one's out of Los Angeles. But you could see pretty much what they're going for, anywhere from, in this range. So artificial disc cases can be serious. I would say full-blown fusions are probably going to be worth more, but artificial disc cases do have substantial value, as it's a surgery and it's a serious injury. I haven't seen too many of them being done in New York for whatever reason. But in California, they seem to be very, very popular. In New York, we have more like the pain management, which is the percutaneous discectomies, epidural steroid injections, which I think ablations, which you have pretty much everywhere. So I hope this was helpful. Let us know what questions you have. Please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. And I actually got this t-shirt at one of my trial lawyer university friends. I will be your champion, because that's what we do, right? We try to be champions and heroes for our clients. Okay, everyone, have a great day. Bye bye.